Trump Legal Cases Daily Digest, January 29, 2024. Hello and welcome back to News Media Hans Daily Digest. Trump's financial monitors report amplifies legal risks. Explosive findings raise stakes in civil fraud case. As the civil fraud case against Donald J. Trump unfolds, an independent monitors report has cast a stark light on alleged financial reporting deficiencies within the Trump Organization. Published on January 29, 2024, by Jonah E. Bromwich and Ben Protess, an article on the report by Barbara Jones, a former federal judge, could significantly influence the verdict in the New York Attorney General's case. The accusations, ranging from missing disclosures to questionable loans, amplify the legal risks faced by the former president and his family business. The Monitor report underscored various documentation challenges within a family-owned enterprise endeavoring to overcome a historical pattern of inadequacies. These challenges encompassed absent disclosures, typographical errors, mathematical inaccuracies, and inquiries surrounding a $48 million loan involving Mr. Trump and one of his affiliated companies. Presently serving as a partner in a law firm, Ms. Jones conveyed to the presiding judge that, when considered together, these issues may reflect a lack of adequate internal controls. Monitor's alarming report and Trump's defiant response. Barbara Jones's report, commissioned by Justice Arthur F. Engoron, detailed various irregularities in the Trump Organization's financial reporting, including missing disclosures, typos, and questions surrounding a $48 million loan. Trump's legal team countered these allegations, vehemently questioning Jones's credibility and accusing her of acting in bad faith. Clifford S. Robert, one of Trump's lawyers, argued that the Monitor was manipulating immaterial accounting items to justify her continued appointment, setting the stage for a heated legal battle. The Trump entities of course never said the loan did not exist, Robert added. Rather, they provided a copy of an internal memorandum reflecting simply that no liabilities or obligations are outstanding under the loan at that time. Potential consequences: $370 million penalty and business bans. The stakes are high as Justice Engoron prepares to rule on the New York Attorney General's request for a penalty of approximately $370 million. This follows a separate defamation case that resulted in an $83.3 million judgment against Trump. The report and subsequent legal maneuvers bring into focus not only financial penalties but also the potential barring of Trump and other defendants from running any company in the state. This intensifies the legal scrutiny on Trump's financial practices and business operations. Trump attacks financial monitor overseeing his business fraud case. Donald Trump launched a scathing attack on Barbara Jones, the independent financial monitor overseeing the Trump Organization, just days after she reported various issues, including a questionable $48 million loan, in the former president's New York civil business fraud case. In a letter to Manhattan Supreme Court Judge Arthur Engoron, Trump's attorney, Clifford Robert, accused Jones of seeking to justify the continued receipt of millions of dollars in fees and claimed she had collected over $2.6 million in 14 months. Robert contested Jones's findings, particularly her accusation that the Trump Organization provided incomplete or incorrect financial information, including a loan that Trump himself had with an entity related to Trump's Chicago Tower. Despite Jones's assertion that the loan did not exist, Robert called it a demonstrable falsehood, challenging her competency and arguing against continued oversight. The dispute unfolded as Jones submitted her report just days before Engoron was expected to deliver a verdict in the civil fraud case filed by New York Attorney General Letitia James against Trump, his two adult sons, and the Trump Organization. The case alleges fraudulent inflation of Trump's asset values to obtain financial benefits. Robert criticized Jones for alleged errors and accused her of being unabashedly self-serving in her report, portraying it as a deliberate effort to ensure the continuation of her role in fees. The clash further intensifies the legal battle, raising questions about the credibility of the Monitor's findings and the ongoing oversight of the Trump Organization. Trump's potential $450 million legal blow threatens majority of cash reserves. Former President Donald Trump is confronting a severe financial threat as he awaits the outcome of two critical legal cases in New York, which together could wipe out a substantial portion, if not all, of the cash he claims to have on hand. A recent jury verdict ordered Trump to pay $83.3 million to writer E. Jean Carroll for defamation, and a decision in New York's civil fraud trial seeking the return of $370 million in illegal profits is expected imminently. In a deposition last year, Trump disclosed his cash stockpile as substantially in excess of $400 million, with the Bloomberg Billionaires Index estimating his liquid assets at around $600 million. The convergence of these legal blows, totaling over $450 million, highlights a potential cash problem for the former president, especially as he faces mounting legal bills from 91 criminal charges across 4 prosecutions. The timing is particularly unfavorable for Trump, who, despite strong campaign finances, may not use those funds to settle personal damages. His attorney, Alina Habba, denounced the financial penalties as selective prosecution against the clear Republican nominee. Trump's net worth, pegged at $3.1 billion, is primarily tied to real estate, with a $450 million worst-case penalty representing nearly 15% of his estimated net worth. The potential escrow of funds pending appeal further complicates Trump's financial landscape. As he vows to appeal both verdicts, the outcome of these legal battles may not only impact his wealth but also raise questions about the sustainability of his financial position amidst ongoing legal challenges. Trump's theatrics in court, a preview of his legal defense strategies. An article by Maggie Haberman and Kate Christobeck in the New York Times discusses Trump court appearances. In recent civil trials, former President Donald Trump's courtroom conduct has become a spectacle, providing a glimpse of how he might approach his 4 pending criminal cases. The trials, including the recently concluded defamation case where he was ordered to pay $83.3 million to writer E. Jean Carroll, showcased Trump's disdain for both the legal system attempting to hold him accountable and the established protocols of courtrooms. This behavior not only drew attention to his public persona but also served as a potential indicator of his strategy in the more serious criminal proceedings ahead. During the trials, Trump's actions at the defense table were telling. He expressed his displeasure openly, often engaging with his legal team and visibly reacting to the proceedings. His use of the courtroom as a platform to communicate messages, coupled with his defiance of courtroom etiquette, hinted at a strategy focused on maintaining control and shaping public perception. These theatrics were particularly notable in the defamation trial and the ongoing civil case related to business fraud, both of which allowed Trump more flexibility in attendance than his upcoming criminal trials. In the face of serious allegations, Trump's behavior reflected a calculated effort to influence the narrative. Authors recall when Roberta Kaplan, Carroll's lead attorney, delivered her closing arguments excoriating Trump for continuing to defame her client even after being found guilty of such conduct at the earlier trial. "Even if you don't like a jury's decision, you are supposed to follow it," Roberta Kaplan said. "Those are the rules. This doesn't depend on your politics, it doesn't depend on who you vote for or whether you support a particular policy or a particular party. We all have to follow the law." Donald Trump, however, acts as if these rules and laws just don't apply to him. Despite facing stern remarks from judges, such as threats of being removed from the courtroom, Trump continued to push the boundaries of acceptable conduct. His willingness to disrupt proceedings and challenge court decorum underscores his belief in his ability to navigate the legal system on his terms. As the spotlight intensifies on Trump's legal battles, his theatrical courtroom strategies may play a pivotal role in shaping public perception and influencing the outcomes of the impending criminal cases. Retired judge recommends removal of Trump from Illinois primary ballot. In a significant development, a retired judge, Clark Erickson, recommended on Sunday that former President Donald Trump should be removed from Illinois primary ballot, asserting that there is clear evidence of his involvement in the January 6, 2021, attack on the U.S. Capitol. Erickson, a longtime Republican judge, submitted a 21-page recommendation to the Illinois State Board of Elections, arguing that a preponderance of the evidence supports the conclusion that Trump engaged in insurrection. While Erickson acknowledged the complexity of the constitutional analysis required for such a decision, he emphasized that, regardless of the board's stance, Trump's name should be excluded from the March 19 primary ballot. The Illinois State Board of Elections is set to deliberate on the recommendation on Tuesday. The case mirrors similar efforts in other states, with the U.S. Supreme Court scheduled to hear arguments next month regarding the removal of Trump from Colorado's ballot based on a historic state Supreme Court ruling. Despite Erickson's recommendation, the board's bipartisan nature, evenly divided between Democrats and Republicans, adds a layer of complexity to the decision-making process. Free Speech for People, leading the Illinois ballot effort, praised Erickson's analysis while asserting that Illinois law empowers the board to make the final decision on Trump's ballot eligibility. Trump's campaign has not yet responded to the latest development. Supreme Court grapples with amicus onslaught in landmark Trump 14th Amendment case. The U.S. Supreme Court is facing an inundation of amicus briefs in the pivotal case involving former President Donald Trump's appeal of the Colorado Supreme Court's ruling that he is ineligible for the state's 2024 ballot under the 14th Amendment's insurrection clause. With hundreds of pages filed by constitutional law experts, state elections officials, and a plethora of Republican figures, the briefs delve into critical issues such as whether Section 3 of the 14th Amendment requires congressional action for enforcement and the interpretation of Trump's alleged engagement in insurrection during the Capitol attack. Approximately two-thirds of the amicus briefs support Trump's appeal, including prominent Republicans and the Center for Constitutional Jurisprudence at the Claremont Institute, while only one Democratic officeholder, Michigan Secretary of State Jocelyn Benson, filed a brief urging the court to provide a decisive ruling for the sake of electoral efficiency. The legal clash, scheduled for oral arguments on February 8, sees a diverse range of opinions. Jonah E, representing the Claremont Institute, argues that Section 3 can't be enforced without an act of Congress, while constitutional law scholars, including Douglas Laycock and Deborah Pearlstein, counter that such an interpretation contradicts the Constitution's Supremacy Clause. The dissenting voices highlight the complexity of the case, with Justice Carlos Sammer emphasizing the absence of congressional legislation under Section 5 and constitutional law professor Seth Barrett Tillman cautioning against deciding the case solely on the self-execution issue. The Supreme Court faces the formidable task of navigating these diverse perspectives to determine the eligibility of Trump for the 2024 ballot. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.